The law in Illinois presumes that all adults over the age of 18 are capable of making their own decisions. In cases where an individual is or becomes disabled and is not previously designated a substitute decision maker through powers of attorney, a guardianship may be needed. A person may be disabled due to mental deterioration, physical incapacity, mental illness, or developmental disability. Generally, in order to file for a guardianship, a licensed physician will need to meet with the alleged disabled person, state a diagnosis, and also an opinion as to whether that individual is partially or totally incapable of making personal and/or financial decisions. Any person can file for a petition for appointment of guardian for an alleged person with a disability. A petition is required to first state the alleged disability and also to nominate a guardian of a state and/or person. Generally, to act as guardian for someone, you must be over the age of 18, a resident of the United States, never yourself been adjudicated a person with a disability, and never been convicted of a felony. In order to protect the rights of alleged disabled individuals, who are also known as respondents in guardianship cases, the Illinois legislature has put safeguards in place. One of those is the appointment of a guardian ad litem. At the outset of a guardianship case, the court will generally appoint a guardian ad litem. The role of the guardian ad litem, or GAL, who is generally an attorney, is to meet with the respondent, inform them of the guardianship petition and its contents, and inform them of their rights in the proceedings, which include but aren't limited to the right to an attorney and the right to a trial. The guardian ad litem is also tasked with observing the respondent and making a report to the court of their findings. If a respondent agrees to a guardianship and all of the requirements of the statute are met, including personal service on the respondent and notice to required individuals, the court will appoint the nominated guardian at the first court date. If a respondent objects to the guardianship, the petitioner will need to prove at the trial that the respondent is a person with a disability and that they are in need of a substituted decision maker. It is important to note that the goal of any guardianship is to protect a disabled individual within the least restrictive means. If there's an emergency situation, a petitioner can ask the court to appoint a temporary guardian to act with specific authorities until the case is ultimately resolved. If any party believes that an alternate guardian should be appointed for the respondent, they can file what is known as a cross petition, and the court will ultimately decide the most appropriate guardian. Once someone is appointed as guardian of person and/or estate, the court will monitor the case until either the person under guardianship can be restored or until they pass away. A guardian will need to seek the court's permission for many actions and will also need to account and report to the court at least yearly. A person under guardianship has been financially exploited due to their disability. A guardian may file what's called a citation to recover assets which were improperly taken, with the goal of recovering them to be used for the person under guardianship. Guardianship can be a complicated and involved process, and we are here to help our clients navigate it every step of the way.